Hello and welcome to Lokojano podcast. My name is Srishti, host for today's session. Today we are going to discuss about the concept of personality rights in India. Recently we have seen cases where celebrities in India have tried to protect the unauthorized use of their names, voice, likeness, persona, and other distinct personality traits. To understand this personality or celebrity rights in depth, we have a very special guest today, Mr. Utsav Mukherjee. Mr. Utsav is a Delhi-based lawyer practicing in the domain of intellectual property, civil, commercial, constitutional, arbitration, public and technology law. So welcome to the podcast, Utsav.
Hi, thank you for welcoming me.
Before we start, can you just tell us about your inspiring journey to our audience?
So I started practicing in 2018 and I worked with a number of offices. At present also I'm affiliated with a law firm. So I work in affiliation with a law firm, but I work in different areas of law. And some of my main areas of law today are intellectual property and technology law, also civil and commercial law. Right. So this includes litigation, advisory, trademark prosecution, all of that. Before being affiliated with this current firm, I worked more on constitutional matters. So I was on a lot of these famous writ petitions, such as the marital rape case, and even the recently trending same-sex marriages case. I was initially a part of that before the High Court. I wasn't there before the Supreme Court, but I wasn't there in the High Court. And now I've taken a leap into intellectual property laws because I feel that right now this is an area which has a lot of potential, and I get to work on a lot of exciting cases in IP law. I worked on this copyright matter recently where they're discussing whether songs can be played in marriages without a proper license and all of that, and different trademark infringement cases and all of that. So it's been very exciting, and I genuinely enjoy the day-to-day work of being a lawyer and resolving people's problems, of putting people's arguments before the court in writing or orally. So yeah.
Thank you so much. That's really inspiring. Coming to the topic, now personality rights have been in the news lately, like the recent Amitabh Bachchan's case on personality rights. So before that, can you just explain to us what exactly are these personality rights?
So personality rights are basically the rights that vest in a famous individual or a celebrity, right? So anybody whose personality is something that they can actually monetize from, which has a lot of recognition, like film actors, famous YouTubers, serial actors. These people have personality rights or publicity rights.
Okay, that's really interesting. Now, when we talk about personality rights, can it be considered as an extension of right to privacy?
Well, I would say the right to privacy is actually a much broader and bigger right. So the right to privacy is a fundamental right under Article 21 of the Constitution of India. And this is a right about the personal autonomy of a person, their right to prevent interference by other people in their personal lives, right? And publicity rights, personality rights are actually uh, more than that, and very different from that, in the sense that publicity rights will only vest in a person who's a public person, right? Somebody who has a public personality, like a politician, like explained, or a celebrity. And when their rights are misappropriated without their consent and they're monetized, so it becomes a tort or a civil wrong under the law. It becomes these celebrities then have common law remedies, right? Like the under the law of torts, and it's different from privacy, which is a fundamental right.
Yeah, that's interesting. Now, coming to the statutory recognition, do we have any statutory recognition of this personality rights in India till now?
Well, we don't really have any statute actually which expressly recognizes personality rights or publicity rights in India. And there are, however, many judgments and court orders which have upheld this and expanded upon this right through the judgments. Because, like I said, it's based on tort law. So, tort law. Let me explain a bit what is tort law, since I'm referring to it again and again. Tort law is basically there are principles of common law. So, common law countries are, as many people know, all of those countries which were once under British colonial rule, and their legal systems are unfortunately based on British law, right? So certain common law principles are applicable in all of these countries, which were under British rule, and where the legal systems are established by the British. So Australia, Canada, UK, India, these are all common law countries. So they all have some common law principles in common. So personality rights, since there's no statute which recognizes them in India, they're based on these common law, tort law principles. And tort law principles, particularly, are those which pertain to civil wrongs, right? So things such as defamation or personality rights, these are civil wrongs under tort law.
So we don't have anything like under our constitution or under IPR till now. It's just under the tort law.
Basically, yes. You won't find personality rights defined under any of the IP statutes in India, such as Trademark Act or Copyright Act. But what happens is that these civil remedies are often uh, enforced along with IP remedies, right? So, for example, when a celebrity files a case for personality rights infringement, then there are also IP rights which are infringed under the Copyright Act, and they generally seek these remedies together. So you'll find a lot of these personality rights being enforced in IP suits. As far as the constitutional remedy is concerned, so in some cases there is also a violation of the right to privacy, so that can be enforced along with this right. But in most of the cases, these are very distinct rights, because there can be violation of somebody's personality rights without violating the right to privacy, right? So for example, Amitabh Bachchan's voice is out there in the public domain, and you use it to monetize your product, to endorse your product without his consent. So that would be a violation of his personality rights, but it would not be a violation of his right to privacy, because those two are separate in this case, because it's already out there in the public domain, so there's no violation of privacy, but there is a violation of personality rights.
So in the absence of any legal basis, how do our Indian courts analyze the situations? Like what difficulties our Indian courts have for deciding the cases on personality rights in India?
So basically, courts, interpret these rights on a case-to-case basis, and because we have precedent-based legal system in India, so one case once decided is relied upon in the second case also. So I'll tell you a bit about the few of the cases that I know about on personality rights. So there's this one famous case called DM Entertainment versus Baby Gift House and others. And in this case, Daler Mehndi, the famous singer, sued a business house for selling dolls that imitated him and even sang lines from his famous compositions, right? And the basis of his suit was that the defendant misappropriated his personality and marketed it without his consent. So the court granted an injunction in Daler Mehendi's favor, holding that the defendant used his persona and unique traits to increase their own sales and were thus liable for wrongful commercial use of his goodwill and value without his permission. And now, since I use the word injunction, let me tell you what an injunction is. Injunction is basically a temporary order which the court grants to protect somebody's rights till the case is finally decided. So, for example, if I sue somebody for trademark infringement, so I'll seek a temporary injunction before the case is finally decided, like fully decided, to prevent the defendant from using my trademark while the case is pending. And the same thing can happen in personality rights suits also. That ex celebrity files a suit for personality rights infringement and seeks that the court prevents the infringement of this right till the time the case is pending, and if it until the time it is finally decided. And once it's finally decided, it can be both in favor or against the celebrity or against the plaintiff who files the suit. So this is one case. Now there's another famous one, which was called Titan Industries versus MS Ramkumar Jewelers, and this is a case related to Amitabh Bachchan and Jaya Bachchan, who are both very very famous and revered celebrities in India. And in this case, the plaintiff Titan Industries sued the defendant for using the personalities and the images of the Bachchans without the consent of Titan, which had an exclusive license to use this to endorse their own jewelry, and without the consent of the Bachchans also. And the court upheld the publicity rights of the Bachchans in this case, right? Then later there was another case, Amitabh Bachchan versus Rajat Negi and others. This is a very very recent case, a few months ago, filed before the Delhi High Court, where the court granted an injunction in favor of Amitabh Bachchan against the defendants for usurping his personality rights, saying that his personality rights had already been upheld in this Titan versus Ramkumar Jewelers case, which I just mentioned. So these are the three cases related to famous celebrities. Now I can tell you about another fourth case, which is very very recent, based on cricket players. Is the digital collectibles case, and in this case, the Delhi High Court is examining the publicity rights of cricket players, which the plaintiff said only vested with itself, right, as per a contract that it had with these players. So the plaintiff in this case is a gaming platform, and the defendant who the case was filed against was also a gaming platform. And in this case, they said that, the plaintiff said that the other party, the defendant, has usurped these rights of the cricket players and used the personalities without their consent and without the consent of the plaintiff, which had the exclusive license to use their personality traits and pictures for their own platform. So, what the defendants actually did, they didn't use the photographs of the players, they used artwork which looked like the players to make digital NFT cards which are then being traded on its platform. So the plaintiff sought an interim injunction to restrain the defendants from providing NFT cards with the players, right? And the defendants, on the other hand, argue that the details of these players, which were being used to make the digital NFT cards, were already available in the public domain. So they argue that there is also no legislation on publicity rights in India, and since these, traits and these pictures that were used to make the artwork of the players are already there in the public domain, so there is no infringement. But the plaintiff then cited all these judgments that I had referred to before, like the Daler Mehendi case or the Amitabh Bachchan cases, to support their argument pertaining to violation of publicity rights in India. However, the court was of the view that those judgments were rendered in favor of the celebrities, but never recognized the right to publicity as an absolute right, and had actually held that the defendants were liable only for passing off by drawing an association to the celebrities with their own products without the consent and then to monetize the value of the celebrities for their own products, right? And the court found that the traits of the players that were used by the defendant in this particular case, in the digital collectibles case, was only to make digital NFT cards, and that these traits and these artworks that they made were only made from things that were available in the public domain, and they made it all on their own, so they didn't really copy, and thus there's no special license required. It's not like they copied the entire photograph or they copied somebody else's artwork. They made their own artwork, so the court found that there was no violation. And the court also said that since the defendants were only using artwork rather than real photographs, so that also itself is not an offense. And most importantly, the court said that since there was no sign of any attempt to make any kind of endorsement, you know, there's no signature of the players on the digital NFT cards. There's nothing done to show that the players were endorsing their platform or their product. So that's why there was no case, and the court basically denied granting injunction. Although the main case is still pending, only the injunction was rejected. But the injunction or that temporary relief was not given in this case. However, this decision to deny the grant of injunction has been appealed by the cricket players before a division bench of the High Court just a few days ago.
Really interesting. Now you were talking about that case, like this personality rights is not absolute, and can we take freedom of speech and expression as a defense in future?
So the freedom of speech and expression, which is guaranteed as a fundamental right under Article 19, is one of the main grounds used as a defense in cases of infringement of publicity rights or personality rights. And the courts have said that this fundamental right cannot be made subservient to, or in simpler words, considered less important than, the tort remedies that are invoked to protect publicity rights. However, if in a certain case it is found that the defendant has violated both personality rights and the right to privacy, which I have explained before are distinct rights, then the plaintiff would have a good case. And this is because the right to privacy, which falls under Article 21, the right to life and personal liberty, is also a fundamental right and is sometimes even treated as the most important fundamental right, one of paramount importance.
Interesting. Now coming to jurisdictions, how does this law on protection of personality rights varies in different jurisdictions, and what can we learn from them?
So, in common law jurisdictions, ones which have had the British legal system, such as UK and Australia, the tort of passing off is sufficient to deal with wrongs related to misappropriation of goodwill and reputation of a celebrity. And the rule is applied similar to that of the digital collectibles case, right, in these jurisdictions. So it must be shown that the defendant made an attempt to draw a connection to or mislead consumers into believing that the celebrity endorsed the product. And in the US, the right to publicity is explicitly and statutorily recognized on a state-wise basis. So basically, the difference is that in UK and Australia, it is based on the tort of passing off and is interpreted on a case-to-case basis, where it must be shown that the defendant made an attempt to draw a connection to the celebrity to endorse their own product without the consent of the celebrity. Where in the US, these rights are recognized on the basis of statutes, and there are statutes in different states of the US. Each state has its own statute on publicity rights, or sometimes they might not also. So that's the way it works in the US and in these other jurisdictions.
Yeah, that was really interesting. Now, coming to the end of the section, what do you think could be done better to create a strong legal foundation over protection of personality rights in India?
I feel that a regulatory framework could be made by a certain ministry, such as the Ministry of Information and Broadcasting, to regulate these rights. And then further development of jurisprudence on such guidelines and cases or suits based on the tort of passing off, like explained, will only happen over time, right? The jurisprudence will develop with the passage of time, as it already is being done. But guidelines can be made. That's what I believe.
And what could be your concluding remarks in the age of social media, influencers, and celebrities coming up every now and then? What could be the future of this personality rights in India?
I feel there may be many such cases or many such legal issues that may arise on personality rights, because we are having, with more and more platforms such as OTT, such as these, social media, YouTube, all of these things. There are more and more celebrated persons coming about, and they have their personality rights, which are actually being usurped without their consent all the time. So, whenever they feel that their personality is being used to monetize, to make money without their consent, there will be cases, there will be legal notices issued, there will be, contracts or licenses being made on this. So there's a lot of potential in this area, and it's a subset of IP practice. And I feel that lawyers will get busy, working on these issues. And people who have, celebrated personalities will definitely need to protect these rights. And like they already are doing in many cases, it will develop even further.
Thank you so much for the wonderful session. It was indeed helpful for our audience in understanding this complex topic. If our audience have any doubts or comments, let us know in the comment section, or you can contact Utsav via his profile link in the description box. To follow us for more such sessions in the future. Thank you, goodbye, and take care.